So what happens after you or your loved one get arrested? The first thing that's going to happen is obviously law enforcement is going to try to book you. They're going to put you through the process. They're going to try to get you to answer questions potentially about the offense. You need to know to invoke. Don't make any statements. The booking process, let's say you invoke, you say, I'm not making any statements. The booking process before you see a judge could take anywhere from 4 to 8 hours. So if you call a lawyer, let them know they got booked or taken at this particular time so we know when they may see a judge, which brings us to the next step. The next step in the process is they have to see a judge. They're entitled to see a judge within 24 hours of their arrest. It's called an initial appearance. At that initial appearance, that's where release conditions are set. So where there's a bond, if there's a homicide, could be they're non-bondable, or maybe it's $1 million bond, things of that nature. Having a lawyer there to argue for the lease owner's release conditions is something that can happen at that early step. So after the booking process, the person may take about 8 hours to be booked with law enforcement through the department, all the way up until the time that they're brought to the court to see a judge. You are entitled to see a judge within 24 hours of your arrest in order to have release conditions set, meaning to have a judge decide whether or not you're going to be held on bond, released on your own recognizance, released to pretrial services, released to a third party, things like that. So when you're calling lawyers, let them know exactly when it was you think that the person was taken by the police so they could get some idea as to when the initial appearance is actually going to happen. After the initial appearance has happened and release conditions have been set, the state may do something called filing a complaint, right? So they may file a written complaint about the charges in the case. If the person is in custody and a complaint has been filed, they are entitled to a preliminary hearing or a grand jury indictment within 10 days of their arrest. Otherwise, they have to be released. There's still statute of limitations, things that apply. Somebody could be indicted later on within 7 years for most felonies. But the next step in the process is that probable cause finding, either a preliminary hearing in front of a judge or the secret proceeding with a grand jury where the state presents a witness who claims this is what happened in the investigation, and then the grand jury makes a finding of probable cause, which is a very low standard. After the preliminary hearing and grand jury finding, you have the arraignment, which is the starting line of a case. That is where the deadlines get set up. You're entitled to a jury trial within 180 days after arraignment if you are in custody. It's longer than that if you're out of custody, and if the case is more complex, it's at least 270 days from the date of the arraignment. Also, you should be getting discovery, at least police reports, within 30 days of the date of arraignment. Other discovery like recordings, forensic evidence, things of that nature, body-worn camera, will take longer just given the process, but that is the starting line, is the arraignment. From there, once you get the discovery, you'll be meeting with your lawyer to talk to them about the issues in the case, talking about the issues from a trial perspective, what are the factual issues at trial based on the discovery in the case, and also what are the pretrial issues, the constitutional issues, Fourth Amendment issues, Fifth, Sixth, Eighth, 14th Amendment issues. While you're meeting with your lawyer, you'll be thinking about trial, thinking about all these issues, and also whether or not you can negotiate some sort of beneficial plea agreement to avoid the exposure of prison at trial for most cases. That is sort of the process, the arraignment, all the way up until the end of the case, which is trial or some sort of resolution through a plea agreement. If you are doing a trial, or even if you're going to enter a plea agreement, at some point during that process, you're likely to do something called a settlement conference, where a judge acts as a mediator between the defense and the state to see if there's something that could be worked out beneficially with the state. There is no constitutional right to a plea agreement, however, so during that process, a lot of the discussions will be related to trial and the pretrial issues. As trial approaches, you'll be doing more things with your lawyer. You should be spending more time with your lawyer as trial approaches, prepping your possible testimony, getting you used to what it's like to be in trial. The lawyer is doing a ton of work as it gets closer to trial. A lot of work should be done in the beginning throughout the process when reviewing things, reviewing all the discovery, reviewing it from a trial perspective. But as things get closer, you start narrowing down the scope of what you're doing and focusing on what needs to be done within the trial. That's part of the process when prepping the trial. After potentially a loss at trial or after a plea agreement has been entered, there's something called a sentencing. That is where the judge issues the sentence. If your case was, let's say, a case where the judge is mandated to sentence you to prison, at sentencing, you'll be advocating, or your attorney should be advocating, for the least amount of prison time. If you took some sort of beneficial plea agreement, it could be something like probation, could be some sort of prison range. Again, the same thing happens at sentencing. Your attorney should be advocating for the least amount of time. If you're talking about probation, there might be certain types of probation terms you're going to be talking about, or your defense attorney is going to be talking about at sentencing that the judge may be issuing. And then also, as a condition of probation for any type of case, a judge can has the discretion to give up to 12 months of jail as a condition of probation. Jail is different than prison. So a judge could say, look, I don't like what you did in this case, I'm going to give you 3 weeks, I'm going to give you 6 months, I'm going to give you 8 months, I'm going to give you all the way up to a year. That is what happens at sentencing. And then after sentencing, you have 90 days from the date of sentencing to file something called a motion for post-conviction relief. And then there's other deadlines obviously associated with an appeal if you were to lose at trial. So that's just a general overview of the process.